Good afternoon, everyone. Thank you for tuning in at the iLaw Lunchtime webinar series, Artificial Intelligence and Intellectual Property. We have created this 40-minute introductory webinar targeted for technology industry workers, both lawyers and non-lawyers like you, who would like to learn a bit about the basics and application of IP to AI over lunch. Today, we are pleased to have our director, Justin Ellis, and our guest speaker, Peter Arrowsmith from Gill, Jennings, and Every. We'll be sharing some pointers and things to consider on patents and copyright on the AI front. We'll also have a Q&A section at the end, which our speakers will try to answer your questions live. If you can choose to participate anonymously as well when submitting the questions. So before getting started, I believe Justin would like to say a few words.
Yeah, thanks very much, Bonnie. I just wanted to spend a couple of minutes at the start of today's webinar putting the session in context by asking, I suppose, three questions. What is artificial intelligence? What's its potential? And how is intellectual property relevant to artificial intelligence? There are many different definitions of AI, but to me, the simplest seems the most appropriate, which is that it's the simulation of human intelligence in machines. This can be extrapolated into the core human functions which AI seeks to mimic in machines, such as learning, reasoning, and problem solving. The scope of exploitation of AI is enormous. One of the leading areas currently is healthcare, where it can have both preventative and curative applications. Another growing area is self-driving vehicles, and there are many applications already in the finance and military sectors. And unless Alexa takes the day off for Thanksgiving, then I'm sure at least some of you will just have had a machine perking up in the corner of your room as I mentioned her name. A research paper by McKinsey last year said that AI could add up to 22% to the UK's GDP by the year 2030 through AI-driven productivity growth. And it's that economic effect that brings us to the importance of intellectual property rights. Because one of the main functions of intellectual property rights, or IP, is to protect the economic interests of innovators and creators, to provide an incentive to carry out that innovation and creation by allowing people to profit from their creativity. In the limited time we've got today, we're going to look at the two main strands of IP that arise in relation to artificial intelligence: patents and copyright. We're going to look at how AI might qualify for protection, ownership issues, and infringement. And we'll also consider whether the law is quite right as it stands or whether it needs to do some catching up with technology, as is so often the case. I'm delighted that Peter Arrowsmith, a partner at patent and trademark attorneys Gill, Jennings, and Every, has joined us today to talk about the patent side of things. Peter has been dealing with patents in the IT sector for many years, and I know has a particular interest in artificial intelligence. So over to you, Peter.
Thank you, Justin. Now then, let's see how this technology works. I share this and then click present, and now I just have to do a little flip. There we go. Now, hopefully you can all see that. So thank you very much for that, Justin. Yeah, Justin's asked if I could give you an overview of patents in AI in just 15 minutes, which is a bit of a challenge to do. But we'll try and talk a little bit about those three issues that Justin mentioned, which is eligibility, what kind of innovations in this area can be protected, ownership, and infringement issues as well. So to think about patent eligibility, the best place to start is to look at what the general rules are for patent protection for software. So you often read in the media that software is not patentable in Europe. You can't get any patents for software. That's not true at all. It's what I do all day, every day. So thank goodness software is patentable in Europe, but critically not all types of software are patentable. Only particular types of software are patentable, and specifically what the European Patent Office looks for is software which achieves some kind of technical effect. So the challenges for protecting software stem from Article 52 of the European Patent Convention, which I've set out in this slide here, some extracts from it. So that says that the following things in particular shall not be regarded as inventions, and that includes mathematical methods and programs for computers, among other things. But it goes on a little to say that patent applications are only excluded if they relate to computer programs or mathematical methods, if they relate to that subject matter as such. So if it relates to more than just a computer program or a mathematical method, then it may be patentable. And specifically, if the computer program achieves a technical function, then those are the types of innovations which can be protected with patents. So I think the best way to illustrate this is really with a few examples to try and show the kinds of things that can be protected and those that can't. So when examining for a technical effect, the European Patent Office look at it using the so-called problem and solution approach. So they look at the differences between the invention and those things which are already known. They consider the effect of those differences and then ask whether that effect is technical in nature. So in terms of those examples, if I give you one example, in your mobile phone, which you've all got, I'm sure, on your desks, there is a bit of software running which will monitor the strength of the signal that the phone receives from the nearest base station. So that if the phone is far away from the base station or it's in a basement or something like that, the phone will pump out power to try and maintain contact with the base station. And conversely, if the signal strength the phone receives from the base station is high because it's nearby, the phone will reduce its own output power accordingly. The consequence of that is, of course, as you'll have experienced, if you spend a long time with your phone in a basement or somewhere like that, then the battery will drain quite quickly. So if you can reduce the output power when you're close to the tower, then it will better conserve the battery resources of the phone. So although the difference between a phone that has that feature and a phone that doesn't have that feature is entirely in software, there's no physical difference between the phones. The consequence of the software, the effect of the software, is to make the phone better as a technical object. It improves its ability to manage its battery resources. And so inventions of that nature are generally considered to be technical by the European Patent Office and therefore patentable, as long as they haven't been done before. Conversely, if you could imagine a bit of software which was an improved spell checker, or perhaps an improved grammar checker would be a better example, which was better able to detect the position of an incorrect comma. And this is a good example of an invention which could involve machine learning. So you could use a technique which examined a large data set of documents that had been created and subsequently been edited by sub-editors to correct the position of commas. You could use that data set to identify where a candidate for an incorrect comma is present in a Microsoft Word document. And it could do that in a very innovative way that had never been done before. The difficulty in terms of patent protection for that is the European Patent Office would say, well, what effect does it achieve? What problem does it seek to solve? And really the answer there is the problem exists in human linguistics. It's a human problem based on a social construct around grammar rules. There's no problem for the machine that runs the software. The machine that runs the software is not improved as a machine by virtue of the software. And therefore, that's the kind of innovation the patent offices would say is non-technical and therefore not patentable. So those are two examples that kind of demonstrate the kinds of software which can be protected and can't. Whenever you take an example in between, it can be tricky to work out whether it really is doing something technical or not. So if you took, for example, an image processing technique, well, it really rather depends on what the image processing technique does. So if you had developed a technique which put a nice sepia tint on an image so that you could upload it to Instagram, well, the patent offices are likely to say that the effect there is purely aesthetic. It's an effect created based on a social construct, and there's no technical improvement there. On the other hand, if you were to process the image such that you were able to compress it more effectively, or if you were able to somehow improve the resolution in a certain area, but allow the resolution in areas such as away from the face, which aren't relevant, to be of lower resolution, that could well constitute a technical advantage. So that's an example of a technique which could either be technical or non-technical, depending on exactly what it does. So those are the general rules that the European Patent Office uses for analyzing software. Machine learning is kind of a special case of software, and the European Patent Office attempt to use exactly the same principles that I've just described in examining patent applications that take account of machine learning. The view of the EPO is that, broadly speaking, there are three categories of AI invention. So category one is what we call core AI. So these are the algorithms as such, the mathematical techniques that are used for machine learning, devoid of any particular application. Now, the patent offices say that these are mathematical techniques, and as I mentioned at the beginning, mathematical methods as such are excluded from patent protection. So generally speaking, it's hard to obtain patent protection for those kind of core mathematical algorithms. The second type involves generating a training set or training a model, and those techniques can be patentable in the view of the patent offices if they support achieving a technical purpose. And then the third type is use of machine learning as a tool in an applied field, defined by way of technical effects. And generally speaking, this is the most likely avenue for success. So if you're using machine learning in a particular application that does something technical, then that's the best way typically to obtain patent protection, with the caveat that simply claiming use of machine learning for a known application or a known problem is likely to be obvious. So just bolting on machine learning to a known problem isn't unlikely to be enough. There needs to be something qualitative about the way in which you've implemented machine learning, which would render it not obvious. So the EPO have recently adapted their guidelines, and they include a number of sections which specifically deal with machine learning. And that's useful for us as patent attorneys because it gives you some specific examples of the kinds of things which would be considered to make a technical contribution. So in the second bullet point there, the EPO have given an example, which is use of a neural network in heart monitoring apparatus for the purpose of identifying irregular heartbeats makes a technical contribution. Great, it's certainly the kind of thing which would be of use, and you can see the technical utility in knowing whether there are irregular heartbeats is certainly something useful, and as far as the EPO are concerned, would be considered technical. However, in the third bullet point there, just classifying text documents solely in respect of their textual content is not a technical purpose, but a linguistic one. So it's similar really to the example I gave earlier in relation to the grammar checker. If you're just trying to work out what's in a Word document based on its textual content, that's unlikely to achieve a particular technical purpose. And there's a variety of other examples in there which go to similar points. So those are the basic rules that the EPO applies in terms of assessing whether or not inventions will qualify for patent protection. In terms of ownership, ownership of machine learning inventions in general, like all inventions, flows from the inventors. So the first question is, who is the inventor? Who has developed the invention? And that has to be a person. So there have been some test cases which have been reported in the media recently around patent applications which have sought to name a computer as their inventor. Those are the DABUS cases, and they've been filed in various places around the world. And the European Patent Office and the UK Intellectual Property Office have refused those applications on the basis that they do not name a person as their inventor. So as far as the patent offices are concerned, this is to Justin's point, maybe a little bit behind the times, they at the moment refuse to recognize that a computer can be the inventor. So for a machine learning invention, it really is the person who has programmed the computer, the person who has set the task for the computer to work on the particular problem that it's working on. That person will be the inventor, and they are the first owner of the invention, unless, of course, there is some agreement which passes ownership from that person to a company, and that is the most common mechanism is employment. So if you have a contract of employment, usually that will say any inventions that you develop in the course of your normal work would transfer to your employer. Similarly, if you have a consultancy agreement, any good consultancy agreement will specify that any inventions developed by the consultant or contractor will pass to the company that they're working for. In relation to infringement of machine learning patents, well, it's the same story really as applies to patents in general, which is that anything that falls within the scope of the patent claims will amount to an infringement as long as it is in a jurisdiction where you actually have a patent. But there are a few things that one needs to bear in mind when drafting applications in this field to make sure that you have useful protection. So you of course need to make sure that you claim something, you're protecting something in your patent that can actually be infringed. And one thing that we've seen many times is that you have a patent application which protects the steps of training a classifier, so the sort of training steps, which is maybe very innovative, but isn't particularly commercially useful if it's only done once. Often you would do the training step once, and then you've got your trained model, and then it's the deployment of that trained model that you really want to protect. That's the thing which is of value, and that's the kind of thing that you'd want your patent claims to focus on. And you also need to think carefully about the entities which could infringe a patent. So often you have a server, you've got an application, you might have a mobile device, you might have a data set, and all of those things could be located in different territories. So a clever infringer could attempt to circumvent a patent by performing different steps in different territories where you don't have a patent. So it's important to focus the patent on the steps which are of greatest commercial value, which will inevitably need to be performed in the territory where there is the greatest value. So those are some special considerations that need to be applied when in the drafting of machine learning patents to make sure that you've got something which is of value which can be infringed by one of your competitors. So that's my whirlwind tour of machine learning patents. I'll now pass on to Justin, who is going to talk to us a little bit more about considerations relating to copyright.
Thanks very much, Peter. Yeah, let's go through the same technology trial, see if I can get this up on screen. Okay, here we go. So I'm now going to look at three similar core issues that arise in the application of copyright. So how does something qualify for protection in the first place? If something does qualify for copyright, who's the owner of that copyright? And then we're going to take a look at what and also how AI might infringe other people's rights. As we'll see, the answers to those questions are quite different in many cases for copyright compared with the position that we've just heard about on patents. Copyright law in the UK is set out in the Copyright Designs and Patents Act 1988. And given that that's over 30 years ago, you might think that's probably going to be fairly out of date, but for reasons that we'll come on to, actually perhaps it's not so bad. Copyright protects, amongst other things, original literary, dramatic, musical and artistic works. AI is capable of producing all sorts of works, such as works of art, literature and music, but it's probably fair to say that the main commercial application AI are likely to be in the fields of software and data. According to the legislation, computer programs and databases can, believe it or not, be classified as literary works and therefore qualify for copyright. It's in the context of data that I've underlined the importance there of originality, because the Act specifically says that a database can only be classified as original and can therefore only qualify for copyright protection if, through the selection or arrangement of the contents of the database, it constitutes the author's own intellectual creation. So, for example, iLaw's client database, which grows organically and sits on our CRM system, isn't anybody's own intellectual creation, and so would not qualify for copyright. By comparison, a directory, for example, the Yellow Pages, where businesses are broken down by category and listed alphabetically within each category, probably would qualify due to the intellectual effort of the categorization and presentation. It doesn't have to be War and Peace to qualify for copyright. Now, this has great potential importance in the context of AI, because if an AI machine creates a useful database out of an enormous and seemingly random set of input information, can it be said to be the author's own intellectual creation? In my view, probably not, because in current terminology, I think that the references to intellectual and author really can only relate to human intellect. So a database created by AI probably doesn't qualify for copyright protection in the same way as an identical database produced or even just engineered by humans might. Although it's worth pointing out that there is a separate database right which gives similar but slightly weaker protection than copyright, but which may provide protection to databases created by AI. Now, the same problem doesn't exist in relation to non-database copyright works created by AI. For example, if an AI system were to write some software, literature, music, or create a work of art, provided that the new work is original, it doesn't have to be an intellectual creation, because the CDPA says that a protected work can be computer generated, which brings us neatly onto the next issue of ownership. Well, actually, before I go on to ownership, I should also say that UK copyright law is relatively unusual in expressly providing copyright protection for works created by computer. This isn't reflected in most of continental Europe or the USA, for example, all of which so far have stuck to the traditional position that a work must have a human author. In other words, it has to be the direct result of human intellectual endeavor if it's to benefit from copyright protection. Now, when these provisions were being debated by Parliament, the government commented that the CDPA would be the first copyright legislation anywhere in the world which attempts to deal specifically with the advent of artificial intelligence. And that debate was back in 1987, just before the CDPA came into force, so well over 30 years ago. And it largely remains the case that in the UK, we're ahead of the game on this issue, although I'm sure that will change as AI becomes ever more important globally. And the starting point for ownership of copyright is that it's owned by the author of the work, that is, the person who created it. There are some exceptions, one of which is for employees, works made by employees in the course of their employment. And unlike with patents, the copyright legislation says that copyright in works created by employees vests automatically on the employer. As an aside, it's important to note that this doesn't extend to contractors or freelancers, which is why, again, as Peter said, it's always important to have an assignment of intellectual property rights in any contract under which you're getting a contractor or a freelancer to create anything for you, because otherwise the copyright in what they create will vest in that contractor or freelancer. A more important exception for AI purposes is that the Act also says that for any literary, dramatic, musical or artistic work which is computer generated, the author is taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. Now, this might produce some uncertainty. If I've bought an AI system from the creator of that system, and that system has created a copyright work under my ownership, who is the person who's undertaken the arrangements necessary for the creation of the work? Is it me because I now own the AI system and presumably gave it the instructions that led to the creation of the work? Or is it the original programmer of the AI system? The law isn't currently clear on this. And the picture gets even more complicated when different AI systems communicate with each other and collaborate to create their output, which is becoming increasingly possible. Or where, rather than entirely AI-generated works, an AI system merely contributes to the creation of a work alongside human input. In either scenario, it's possible that there would be joint authors for the purposes of copyright law, and therefore joint owners, which creates a lot of potential difficulties which happily are beyond the scope of today's talk. Copyright protects against a variety of acts, including making copies of the work, issuing copies of that work to the public, or making an adaptation of the work. When I talk about work, it doesn't have to be the entire work that's copied. Just a substantial part is sufficient to give rise to copyright infringement. And what's a substantial part is a qualitative test rather than a quantitative test. So copying just a short extract from a book or a song, for example, can easily amount to copyright infringement. Now, copyright protects very differently from patents. In order to infringe copyright, you have to have had access to and copied or adapted a substantial part of the original copyright work in order to infringe. If I independently wrote a book, 1984 for example, without ever having had access to the original, however unlikely that may be, I would not have infringed George Orwell's copyright. Just an aside here, but George Orwell happens to be going out of copyright at the end of this year because he died 70 years ago in 1950. So, in fact, 1984 and Animal Farm and everything will be out of copyright from 1st of January. Anyway, I digress. So, whereas with a patent, I can't even independently come up with some technology that coincidentally replicates a piece of patented technology without infringing that patent. The other important point to note here is that copying takes place whenever a computer reproduces any information, which it has to do in its memory in order to use that information. So even if an AI system doesn't republish part of a copyright work, it can still infringe simply by making a copy within its own system, even if it's only a temporary copy. AI systems, by their nature, rely on existing information, data, and other inputs to learn from. Machine learning is almost synonymous with AI. And much of that information will be protected by copyright or database rights. System owners need to be careful to ensure that they don't infringe other people's rights when they set their systems to task. Although I suppose we've got to query how easy it's going to be to detect infringement, particularly if the system's output is not obviously linked to all of its input. And a side question is a work produced as a result of learning from copyright works original? In other words, can it benefit from copyright protection in its own right? At this point, I should mention that there are a number of exemptions from infringement claims, but those are mostly around non-commercial use, so I don't propose to go into them here. There is a school of thought that the law needs to be adapted to make it more permissible for AI to learn from existing protected works, but also to allow the owners of those existing works to benefit. Because, as I said, it can be hard to detect where there's been infringement. Otherwise, the thought is that growth and the potential benefits of AI may be stunted. Now, looking at the other side of the coin, in the UK, we've already heard that copyright works can undoubtedly be created by artificial intelligence, and that copyright can therefore undoubtedly be infringed. But some commentators ask whether that's ethically right. Should intellectual property rights only protect the output of human creativity? AI can throw out copyright works far more quickly than humans can. Might this result in stifling human creativity? On the other hand, isn't an AI system itself the result of human creativity, and so its output ought to be protected? These may seem like somewhat academic questions, but I've little doubt that as AI becomes more prevalent, they will start to be reflected in real issues. Before I conclude, I just want to say a word about deep fakes, which I'm sure most of you will have heard of. For those of you who haven't, deep fakes involve the generation of simulated likenesses of individuals. And it's another area that's ripe for the exploitation of AI for both positive and negative ends. Now, we're straying out of the bounds of copyright here. Should this kind of activity be legal? Do we need specific regulation for it? Can copyright or privacy law be extended to allow individuals to control deepfake versions of themselves or their works? Hard questions. Really have the answers. So anyway, that's probably about all I want to say. I hope you've found that a useful introduction to intellectual property law. Although we've only had a very short amount of time, hopefully we've managed to get across the point that there are a lot of complexities and also opportunities thrown up by patent and copyright law in the AI context. Both the World Intellectual Property Organization and the UK government recognise that there are potential shortcomings with the law as it currently stands, and they've been conducting discussions and consultations on the interplay between AI and IP. So there will almost certainly be developments on what we've been discussing here today in the very near future, I would imagine. One possibility might be a specific right for AI-generated works, in the same way as was introduced for databases in the late 1990s. And many years down the line, I dare say that AI systems might start being given their own legal personalities and then start being able to own their own intellectual property rights. And who knows, somebody may even make a film about it. That's it from me, so I will stop sharing and hopefully we can move over to some questions.
Thank you, Peter, and thank you, Justin. And we'll now take questions. So please use the Q&A button to submit your questions, and our speakers will try to answer them live for you. As I can see, there are already a few questions. There's one from an anonymous attendee. He or she was asking, how can a company best protect themselves if they are developing a new techniques involving machine learning? Peter, would you like to take that?
Yeah, sure. I mean, from a patent perspective, it's a very open question. I mean, how can you best protect yourself? I think the best thing you can do is talk to an IP advisor about your situation, and they'll be able to advise whether or not patents or copyright or would be the best mechanism. I mean, from a patent perspective, what I would always say is, well, it's important to understand the context of the business. What is the business trying to do in general terms, and then look at the innovation and consider which aspects of it may be protectable by patents and which will not, so that you can come up with an IP strategy that makes sense for the business. Because just because you've got a machine learning innovation which might be patentable does not mean that you should necessarily apply for a patent. I mean, one of the negative consequences of applying for a patent, for example, is that you must disclose the invention. This is the kind of quid pro quo. In obtaining a patent, you get a monopoly in exchange for telling the world how the invention works. Now, if you can safely control the invention, you can keep it in a black box so that no one can see how it's working. You have to ask yourself whether applying for a patent is really the right thing to do. So it's in that sort of situation, it's a balancing act. You know, you need to try and factor in how likely do you think that your patent application is going to succeed. How able do you think your competitors might be able to be to reverse engineer what you're doing and create it themselves? You've got to weigh up the costs. You've got to look at the benefits. The two different companies with different competing interests might well come to different conclusions on similar facts as to what the best thing to do is. So I think the best advice is really to start talking to a patent attorney, to a solicitor like Justin, who has some expertise in this area, and they'll be able to guide you through the process.
Yeah,
Thank you, Peter.
I suppose it's worth briefly commenting on that from the copyright perspective as well, because it's slightly different. You don't have to go through the registration process in order to gain copyright protection. Copyright protection applies automatically. But the difficulty that you then have with copyright is that you have to prove that it was actually you who developed this copyright work before somebody else did. And so it's important to keep evidence of your development. And I think one of the key things in terms of protecting your copyright when developing copyright work, work-based professional copyright work such as software, is to keep a development log. So if you're using an AI system to create software, then you should be keeping some kind of development log that records the instructions that you've been giving to that system, that records the system's output as it's created, so that if need be in court later on, you can go back and prove that this is when the work was created by me, and that guy over there who's come up with something that looks remarkably similar did it later.
Thank you, Justin. And Peter, I think there's another question for you. Do the requirements for obtaining a machine learning patent vary around the world?
Yes, I do, and that I didn't really go into that in the presentation because it's a further complication on what is already a fairly complicated space. But everything I was saying today is really the situation with respect to the European Patent Office. So the European Patent Office is a single patent office that to which you can apply to obtain protection all around Europe, including in the UK. But every country in the world has its own sort of patent system, and the laws vary a little bit around the world. So the US in particular has a different set of requirements to Europe, and the approach to patenting machine learning inventions in the US is rather more liberal than it is in Europe. So some of the examples that I gave earlier on, although they would not be patentable in Europe, may stand a better chance of protection in the United States. And that, going back to the first question, what should you do if you're a company who's developing innovations in this space? Well, what you do in Europe is not necessarily going to be the same as what you do in the United States. And that's why it's important when coming up with an IP strategy to have a sense of what the overall corporate strategy is. So if, for example, you're very much focused on the United States, that's where you see your growth, that's where you see potential exit coming from, then it may well be that having patent protection in the US is of more value than having protection in Europe anyway. So you might feel that if you were to file a patent application, actually filing it in the US would be a better bet than filing it in Europe. And that's a strategy that I followed with several clients in the past. It really varies from company to company as to what the right thing to do is, but yeah, you need to try and get a sense of what the requirements are all around the world, and then try and map them onto where your interests are.
Thank you, Peter. And Justin, I think there's a question for you as well. It says, Justin, I know patents need to be registered. Is it the same for copyright? The mic is muted.
Always handy to unmute if you want to talk, isn't it? In general, due to a network of international treaties, the answer to that is no. Copyright doesn't need to be registered, it applies automatically. Some countries, most notably the USA, do have a voluntary registration system, and registering in those jurisdictions will certainly help you if you need to enforce your copyright there. And I suppose on the subject of jurisdictions, another sort of minor complication that minor qualification that I likewise didn't mention during the talk. Another big difference between patents and copyright is that whereas copyright protection applies more or less globally due to those same treaties, patents are territorial, as Peter mentioned. So you do have to register a patent in each jurisdiction in which you want protection, which is obviously music to the ears of patent attorneys around the world like Peter, whereas copyright applies more or less globally, more or less automatically.
Thank you, Justin. And we also have another question from Mitesh. And the question is, have either of you come across copyright or patent holders in the AI space using litigation funding to assist them in enforcing their infringed patents? Justin or Peter, would you like to take on the question?
Well, I'll give a very brief answer, which is, as I'm not a litigator, I've not personally come across that. I don't know whether Peter has, and I'm sure there have been instances of it.
Not specifically in the AI space, but I mean the same principles apply in other sectors. I mean, I've certainly seen it in a variety of other sectors. I mean, there are a variety of ways of litigation funding. There's IP insurance, so you can have two different types. You have your before the event insurance or after the event insurance, and there's a variety of other techniques that can be used as well. And they can be good things for companies. I mean, before the event litigation insurance is quite expensive, so it's not for everyone. But if you can see the value, then it could well be something which is worthy of consideration. After the event insurance, which is something that you would take out after you have received or after some litigation action has begun, can definitely be something which is worthwhile to help to mitigate some of the potential costs that you would face in defending yourself in court down the line.
And my litigation colleagues would never forgive me if I didn't do a quick plug for them, which is that we are doing an awful lot of work with litigation funders, and as Peter said, I don't think it makes too much difference what the subject matter of the litigation funding is. So yeah, I mean, if you've got a specific issue in mind, Mitesh, then yeah, please do get in touch, because we're working all the time with the litigation funders on that front.
Thank you, Peter and Justin, and thank you everyone for participating in the live webinar. If you have any questions on intellectual property or issues that your company is facing and you would like to discuss with our speakers, you can email them directly, and the email addresses can be found on the agenda. We'll also be sending out PowerPoint slides and feedback form for you shortly. So it will be great if you can just spend 2 minutes of your time to fill it in so we can tailor make these webinars for you. If you would like to rewatch this webinar, or you would like to send it to your colleagues, this webinar will be made available on demand on YouTube shortly. So make sure you follow us on LinkedIn to get updates about it and other future webinar invites. Thank you so much for participating, and we hope to see you again on the next webinar. Thank you.
Thanks very much, everybody. Bye.
Bye.